over and over again for 40 years.
No, my lord, why should they interfere?
Okay, the special leave petition along with the applications for hearing. Application IN number?
My lord, I'll just give the number. IN number. My lord, 102061 of 2023.
For hearing in the week commencing.
And my lord, they should maintain the status quo as directed.
That order is already there.
Yes, the order is already there, my lord.
No, because my lords, they have said not only fit person says
27th of January 2025.
Lordship. I'm deeply offended.
And my lords, I have put in the material to show that these gentlemen were not qualified. They were acting.
We'll examine the whole thing.
My lord, the status quo, my lord, I will
restore, my lords, whatever it
my lord,
was.
we'll see what the status quo was, my lord, and we'll make sure that the order is complied.
They can't speak in two voices.
My
Lord, they may verify because they
We are keeping it we give a very short date.
very well.
is related.
One more thing. So 27th.
Lordship.
Obliged.
God, the LRs have not come.
No, Lords, removed an application.
No, but are you representing the LRs?
No, Lords, I am for the petitioner.
Dev, are you representing appearing for the
Yes,
LRs?
my Lords. Yes, my Lords.
Can
For
we
the
dispense
response.
with the service?
Yes, my Lords.
Can we dispense with the service?
My lords, I'll file my wakalatnama. I have the wakalatnama also. I'll take a couple of days.
It's a very short, small little issue whether there is a valid adoption or not.
Yes, my lords. Yes, my lords. I agree, my lords. My lords may have it any fixed date. I'll just file my because I've received the wakalatnama as well from the others, my lords. I'll please.
Are you also appearing for respondents 2 to 4?
No, my lords. No, my lords.
R2 to R5 have not been served.
No, no, service is complete.
No.
All the
The
office
office report.
if I may just read, my lords. Yes, service is not complete on 2 to 5. I stand corrected.
If my lords will
But
have
they are
this
performer respondent.
page 1 of the impugned order, my lords.
Have you not taken steps for this service? Who are R2 to R5?
My lords, they are performer respondents. No?
Yeah,
You can
they seem to be performer, my lords.
Look, they are,
Who are they?
my lords, they are all related to respondent number 1, my lords.
But they're not.
They have no stake in them because they've
Yes,
been made
they can
parties
be-
in the High Court and that's how
Service can be dispensed as regards.
so their presence can be dispensed with. I am not seeking anything against them.
Oh, can we record your statement that you treat them as performer respondents? They're not affected.
Let it be.
Then we can dispense. On your statement, we'll dispense it
Let it be.
at your risk.
Please.
Learned counsel for the petitioner says that respondents 2 to 5 are performer respondents and hence need not be served at his risk, at the risk of the petitioner. Stop. Next page. Application IA number
IA number is
4031 of 2025 and 4032 of 2025. As there is no objection to these applications by the contesting respondent who states that he will be also entering appearance on behalf of the legal representatives of
So respondent number 1.
respondent number 1, Rukmini Devi, who is that. Hence the applications are allowed. List for final hearing and disposal in the week commencing 3rd of March 2025.
deeply obliged, my lords.
Item 12, Your Lordship, I am being led by the learned ASG, requesting for a short pass-over.
So, what has happened? Decision is taken now.
We've taken a decision, we've placed it on record, Your Lordship.
I couldn't find, where is it?
Your Lordship, this is in the additional affidavit on behalf of petitioner.
Okay, but I was trying to search for it in the morning. I hope. Which page is your decision? I couldn't locate it.
It is an
Your
additional
Lordship, this
affidavit
is
of one
mixture A5,
Ajesh Kumar.
report of the internal committee on recommendation of.
Now you'll have to challenge that.
My lord, this affidavit is not in conformity with the impugned orders. My lord, may kindly have the impugned order, my lord. The specific direction. They have accepted.
What's the date when you filed the affidavit?
23rd November 24.
21st November?
3rd November, my lords.
23rd November.
Yes, I've got it.
On the specific, there are 4 issues that were decided, my lords, and your lordships will find the specific decision at page 79 on issue number 4.
Page?
79, my lords. Starts at 78.
Para number you give me.
Page 7, the top issue number 4, my lords. Whether the methodology.
Yes.
May I read this, my lords? Lordship will permit my colleague to read, my lords?
Yes, please. You're not well?
Just bad throat.
Okay. Should we have it on another day? If
No, that's.
Analysis of the internal committee, reasons for the fixation of OROP rates for various categories ranks at the same rate has not been properly appreciated. This is not an anomaly and has occurred due to application of protection against pension granted to a lower rank when there has been no retiree of the same rank qualifying service in the base year from which data was drawn, that is 2013. Such protection was necessary to ensure that a senior should not get less pension than
Just 1 minute. Which page are you reading? Page 78?
Page 79, Your Lordship.
No. Issue question number 4.
Issue number.
4. Yes. Yes,
Lordship, I'll start from the beginning.
Yes.
Issue number 4, whether the methodology followed for fixation of pension under OROP in the absence of actual retirees in the same rank and same qualifying service for the below mentioned categories requires any modification. Report of the OMJC, yes, the tables must be revised in such a way that ex-servicemen in a particular rank or category, but with different lengths of service are not clubbed for determining the benefit under OROP. If comparable figures are not available, notional exercise must be undertaken. Analysis of the internal committee. Reasons for the fixation of OROP rates for various categories, ranks, at the same rate has not been properly appreciated. This is not an anomaly and has occurred due to application of protection against pension granted to a lower rank when there has been no retiree of the same rank qualifying service in the base year from which data was drawn, that is 2013. Such protection was necessary to ensure that a senior should not get less pension than a junior. Further, notional fixation of pension is a new formulation not prescribed in the fundamental OROP principles. I'm on the view, Your Lordship, on the basis of Honorable Supreme Court's order dated 16th March 2022 and report of the internal committee, this recommendation is fit to be rejected as recommended by the internal committee.
what was their contention?
They wanted that notional fixing should be done. What OROP prescribes is every 5 years it will be
Upgraded.
upgraded. So they said for this post of captain, there are very few people who retire. So you fix it notionally. But we have examples of people who are retiring and their pensions are available every 5 years. We are fixing it on actual basis.
So what has happened is because of the faster promotions or more frequent promotions as compared to earlier.
Yes.
So the earlier retirees at the post of captain, equivalence is very difficult today to find.
That is why equivalence has been brought in. This is nothing to do with equivalence, my lords. The only aspect is when you revise it every 5 years, should you do it on a notional basis or an actual example? That is the only thing. Actually, can we show this from?
You'll have to challenge this.
Would your lordship like?
You'll have to challenge this. We'll not. Look, let me put it this way. Now they can even withdraw their SLP or appeal. They are the appellant before us. You're not the appellant.
Correct.
They can even simply withdraw their appeal.
May I just show the impugned order?
We cannot go into the correctness of that because this is a very highly debatable issue.
May I just show
It's
the
a
impugned
debate.
order? What they are
Say,
saying again?
let me put it, it's going to be contentious and a debatable issue.
My
You
lord,
may be right, maybe you succeed,
may I
but
just make
it's their appeal, they can even withdraw it after they file
They
this.
can do that, my lord. But the thing is, they have come against a particular order. Whatever. I'll just show the.
They are in appeal,
Correct.
you're not in appeal.
Correct. And
You
they
can
have
withdraw
taken
your
3 years.
appeal today.
They have taken more than 3 years to take a
Correct,
decision.
correct.
Now they are saying that we have taken the decision.
1 minute, please. We wanted them to take whatever decision. Now you challenge that. That's all. They're in
May I just show? My lord, these people are now more than 85-year-old.
MA 2752.
The direction, my lord, is what they are showing, my lord, is the report of the internal committee. I'm sorry, my lord.
Tribunal's mandamus at para 7.
Please, my lord. Correct. Tribunal's order, my lord, is 31st 12. May I just show the
In view of the, just come to paragraph 7 at page 10.
my lord, in view of the agreed position, that is what my lord is saying.
Yes.
In my petition, my lord, it is para
In
6.
view of the rival.
In view of the agreed position,
No.
my lord,
In view of the rival contentions.
my lord, that is in the other 12. It is in 12.1. I am in 12.2.
We are in 12.
Both are same. Issue is always same. There are
Okay,
two
read
separate
paragraph
orders. May I
10.
just read what is the order passed in my hand? This is a 31/12, my lord, 2021 order. In 12.1. It is 9103 or 22. CA 9103. May I just read that order? In view of the agreed position by the learned counsel for the applicants and the learned panel counsel for the respondents, and since there is lack of clarity on certain aspects of OROP scheme, we direct that the respondent to decide the pension due to these lieutenant commanders of the Indian Navy as per the anomalies resolved by the Judicial Commission on the OROP scheme and subject to the issue of Government of India letter, disburse the pension at the entitled rate to the officers.
It's not a direction specifically given that the anomaly committee report be accepted. Anomaly committee
No, one man
report
judicial-
is an opinion. It's an opinion. It's not a binding force. It doesn't have that binding force. Now, whatever it is, they can simply withdraw their appeal today, saying that they have complied with that portion, and which, if you want to challenge it, you can challenge that. That's
Lord, that is what I am submitting, my lord. These are all more
no,
than
we will not
85
be
year
able to
old.
go into that.
They are all
Look, this
more
is
than
a
18
contentious.
year old.
We are ourselves saying
it is
it's a
put in-
contentious issue. The opinion given was only to that extent.
May I try to convince my lord not more than 3 minutes? My lord, the fundamental aspect of one rank, one pension is that they belong to the same rank and of the same length of service. We were receiving till the
No, it's not the same rank. It's now the length of service which is the difference.
Yes, my lord. So we were receiving. So there are two aspects of it.
Look, please, we cannot go into all that. We'll have to be very contentious
My lord,
issue. That too, in
my
their
lord,
appeal, we can't
They have
decide.
admitted.
We cannot decide it in their appeal.
May I just say, my lord, they have admitted they will implement the
Be
decision
faster
of the
there.
Judicial Commission.
Right now, we have
My lord,
examined
it
the
is going to
affidavit.
person,
Sorry,
more than 85-year-old, my lord,
Doesn't
is
it-
not going to.
correct? You are getting a pinch.
So
We have gone through the
decided in this.
right now. We have gone through the affidavit filed by additional affidavit filed on
23rd November 24.
23rd of
So it is
November.
not any decision that they have taken. The decision taken
23rd
is
November
fundamentally
2024.
One man, one
In
rank.
closing therewith,
Was converted.
the office memorandum dated 7th November 2015.
But the issue
With-
involved is very small, my lords.
No, we cannot, no, it's not so small as you're thinking.
It is, my lord.
No, it's not.
If I cannot
Please,
convince my
it's
lord
not so,
merits
it's
of the
what
case,
you're
in 5
saying,
minutes,
no,
one
sorry,
man can do that.
it's their appeal, not your appeal.
True.
One, issue is not so simple as you're making it out. It may
Hello.
have, no, there'll be a lot of,
Convinced my lord.
let your,
You
what
gave
you're,
2 reasons.
please, we're not required to clarify, we have clarified for yourself.
My submission, my lord, is there are only 2 reasons given by them.
In closing therewith,
My lord.
memorandum dated, just one. And
My lord, in fact, my
1 minute, please, do not interrupt now. The office memorandum dated 7th November 2015, which also refers to the report dated internal report dated,
It's not dated, my lord.
which refers to the internal report.
There is no date of the internal report.
Date of this.
They relied on one man judicial commission, not internal report.
But Malad, para 11, your lordships will see, government has on 13th September decided not to accept the recommendations.
Okay, which, just strike that off. Affidavit which states that the government on 13th September 2024 has decided not to accept the recommendations made by one man or one member,
One
man
man.
judicial.
one man judicial committee. Commission. Is committee or commission?
Commission.
Commission. Stop. The relevant papers have been placed on record. In view of the aforesaid position, the present appeal referred by the Union of India has become
In that case, my lord, we may be permitted
And-
to revive the.
and is accordingly disposed of. Stop. It will be open to the respondents to take recourse to appropriate remedy if they agree by the decision taken by the government of
My
India.
lord, my only prayer is that we may be permitted to revive OA in view of this and
Please
let them,
go before them.
rather than filing, my lord.
But don't do that. Not necessarily file a fresh OA, it will be faster. Revival will mean you'll have to start the pleadings afresh. Don't do that. File a fresh OA, it will be much faster. Next case.
Because there is almost 85, 86-year-old and it is very.
Doesn't make a difference. It will be faster that way.
Please.
All corrective matter. Yes. It's not just.
My lords, the Arguing Council is not well. So I'm seeking for a short adjournment in this matter for a week, my lords.
I beg to appear for the respondent, my lords. Lordship had directed on the 29th July.
They have filed an affidavit that the electricity and water was connected, but there is
No,
one.
it was not connected, my lords. If Lordship sees it was unconnected, I filed another.
Correct. Was not connected. I said not connected.
Not connected, I'm sorry.
So that's
So I
correct.
just had symbolic possession.
Let me put it, in spite of that fact, this question of waiver of the loan amount is something very difficult.
No, sir, my lord, I paid the entire loan amount. When entire loan amount is paid, it's only this 9-month interest.
Correct. That 9 months interest, waiver of 9 months interest is very difficult.
No, but if it is a symbolic possession given without electricity and water, in that situation, they cannot charge me and the fault was there. They don't even bring to the notice of the DRT when stay is granted.
If you're going to accept this, then it's going to be in all surfacing proceedings, it's going to lead to a huge issue.
Well, actually, these were non-surfacing. That's why I went to order the civil suit.
You are getting benefit of the prices also which you paid. You were not out of money. All that you are paying was the interest. If you don't even pay interest on that amount.
I had paid the entire amount plus interest. In fact, I have paid them more than that.
There are proceedings in the DRT.
Well, nothing. In fact, when I filed NCDRC writ petition, then I filed civil suit. The court inquires whether you filed any proceeding in DRT. Did you declare them NPA? There were no proceedings, so I had no option. Just before 3 years, then I filed the civil suit. And in that, it's my Order 12 Rule 6 application which is allowed, which has been upheld in appeal by the Supreme Court. I have paid the entire principal, I have paid the interest.
No, Ms. Gupta, today only the 711 has been adjudicated, isn't it?
No, my lords. Their 711 was rejected and my Order 12 Rule 6 was allowed. So that was a composite challenge before the High Court. And High Court upheld that.
Suppose.
The issue is whether a civil.
Just 1 minute. See. Order 12 Rule 6 degree will be very difficult to accept.
Well, they are seeking an adjournment. I'll satisfy my lords on the next day. Because an appellant is.
Rule 6, even if we hold that Order 7 Rule 11, the suit may not be dismissed. For the
Yes.
reason that they haven't got to
Well,
the
as
DRT
far
for
as
recovery.
payments are concerned, there is no dispute. I've paid the entire principal
No,
amount.
we are aware of that. You're repeating that. We are aware of that.
Yes.
We are aware of that fact. We
No,
are,
Manoj,
we are,
I'll
we are
satisfy my lords.
concentrating. We are concentrating on the core issue. The core issue is 5% of the amount. For the balance amount, you did take the loan.
Right.
Correct? And it's not the bank's fault that the borrower went into litigation. And
But
that
my lords,
everybody who purchases the property in the Surface Act or DRT is aware that this is a possibility. The bids which are given are always taking into account that possibility of that risk. So the bid prices are lower. Now, the fact of the matter is, bank did not receive that payment. The payment which was made by you was from the bank itself. So what you say is, do not
no,
charge
but
me
I have
for
returned
that
it to the
9
bank.
months or 1 year period. So that's the issue.
9 months
That can be
period.
waived off.
9 months
Cannot be.
period.
And they're
Well,
two separate transactions. Let's not forget, they're two separate transactions.
Well,
And there is
before the DRT, they don't inform.
set off in terms of order 6 rule 8 etc. is different, because this is not what you're seeking is set off, in fact.
It's not a case of set off, my lord. Set off would have been if I had not paid the principal. I have paid the entire principal.
No. Yeah, you're
I
wrong.
have paid the interest.
No,
But
you have not paid the interest for the period. You have not
9
paid
months.
the interest for the period in question.
In 9 months, that is because they don't tell the DRT that the property has already been sold when the stay is granted.
Neither principle of equitable set off will apply, neither principle of legal set off will apply.
Well, I'll satisfy my lords on the next step. Because if they don't bring it to the notice of DRT, that is not my fault. Sale certificate.
What is no, that you must be aware. That's a question of fact also.
Yes, I will place all those facts. Today the counsel for appellant is not there, but the issue is that they don't bring it to the notice of DRT.
Sort it out. Can you pay up 50%?
Well, last time they said we are not interested. The bank said we are not interested in going to Lok Adalat. We had no objection, but they said we were not interested.
What is the total quantum of interest?
I'll just take instructions. Mr. Mittal, what is the total quantum interest in dispute?
It's around 27 lakhs.
And they have 27 lakhs and they've taken, in fact, part of it already from me. In the calculation in execution.
If it's convenient, we can pay 50, 13 lakhs, we will not be bothered about this small sum of money.
Not in fact, as per their if I may submit, not as per their reconciliation statement, I have deposited the entire 51 lakh rupees before the bank, and the bank said they will issue NOC. They did not issue NOC, and then they filed SLP before this honorable court. The reconciliation statement was made by the bank before the executing court.
Reconciliation statement must be based upon the impugned judgment itself. Reconciliation statement must be based upon the basis of the impugned judgment itself, not on the basis of what is actually as per them due and payable. There is a difference between the two.
Well, this was in execution proceedings, but we'll just find out whether it was based on our as per their accounts or as per the
instructions. If you are ready to pay 13 to 14 lakhs, we can close it up. You also take instructions.
I'll have to take instructions and
you can take instructions.
Yes, Lord.
Relist in the week commencing. 10th of February 2025. In the meanwhile, asking for the parties will also obtain instruction on whether the matter can be resolved on payment of part interest. 49 page. Okay. This will go before another page.
Please.
Right.
This is order of 17th of April 2020.
What is the issue in this case?
Lordship, so in this matter, there is an order of my lords will not for impleting ED. I'm representing ED.
ED and the
But-
corporate.
But
The main appeal challenges an admission of
the
insolvency.
order dated 10/9.
What is the issue in this matter?
There's a challenge to the admission of an insolvency, Malots, by certain so-called shareholders. The concurrent finding is they don't have locus.
Placed before a bench presided over by Honorable Mr. Justice Abhay Oak, recommencing 10th of February 2020.
Issue was whether shareholders can
Obliged.
collect debt. That was the issue.
Obliged, Malots.
Please.
Grateful, Malots.
Obliged.
A matter under the Maharashtra Public Charitable Societies Act.
Yes, please.
A trust became defunct in 1987. It stopped filing returns for a period of 30 years. But such trusts are to be treated as defunct trusts that need to be deregistered. A procedure, my lord, where trustees are put on notice, they would have to respond. Then the officer would proceed, my lord, to treat them as defunct. Notice is issued, trustees don't respond. A public notice also caused, nobody responds. But when this deregistration process was going on, another working trust approaches the assistant commissioner and says, we are interested in taking over this trust because there's a school that is being run by this defunct trust. The Maharashtra Act provides, by applying the doctrine of Cyprus, that there can be an amalgamation of two trusts having similar objects. So my application, my lord, for asking for amalgamation of this trust is accepted, my lord, by the assistant commissioner. After it is accepted, my lord, two things happen. One is a writ petition is filed by the employees of that school, of that defunct trust, because they felt there's a new management coming into force. My lord, the High Court dismisses that writ petition. Separately, my lord, one of the trustees of the former trust who did not respond to the notice files, my lord, an appeal before the joint commissioner saying that I was not put on notice. He does not disclose that he has not changed his address. The address given by him, notice was sent and notice was not received by him. He does not explain why he did not respond to the public notice. But the joint commissioner allows the appeal, saying that a matter relating to deregistration or amalgamation is a serious matter. The trustees need to be put on notice. But without considering whether, my lord, the trustee was already put on notice through a proper proceeding. But writ petition dismissed, stating that since it relates to principles of natural justice, High Court is not inclined. We go back in a review, place all this material before the High Court to state, my lord, that the trust was actually put on notice. The trustees did not respond, and as on today, one sole trustee, one teacher, one peon. My lord, this teacher and peon being the teaching and non-teaching staff who failed, my lord, separate attempt before the High Court failed. My lord, we filed a review. The review now dismissed on the ground that the Act requires, my lord, a gazette publication to be made. In the absence of a gazette publication being made, my lord, the requirements of the statute are not met. But what I have done, I have just made a short 2-page note, just quickly capturing this for your lordship's kind consideration. I'll just complete my submissions in about 5 minutes. Just pass on one. My lord, there was one error in the review order. High Court thinks, my lord, the statute consider.
Is there a requirement in the procedure for gazette notification?
Yes, my lord, it's a mandatory condition.
Gazette
provided that
Not being followed.
Maharashtra Public Trust Act.
Your lordship, my lord, I'll show your lordship's one judgment.
But then if that's not being followed, that has to be followed.
Yes,
My lord, Lord, your lordships are held. I'll show your lordships that specific provision. Specific provision, my lord, provides for gazette publication for the specific purpose of putting these people on notice. And your lordships have held in similar statutes where there's the necessity of a gazette publication.
They may have 2-3 consequences. One, gazette notification is a public notice. Two, it's a normally gazette notification and number of judgments of this court's holding is a mandatory.
Yes, ma'am.
It may relate back, but it is mandatory.
But your lordships have also held that if there's a public notice otherwise caused, may I just pass on one judgment?
No, there are number of judgments, at least under the income tax and other acts, where there is mandate to it.
My lord, 1991 supplement to
Just
SCC
order of
7.
remand, my lord.
My learned friend, my lord, I'm just placing this one judgment. Lordships may just notice this. Para 6, my lord, of 1991 supplement to SCC 753. Sir, extra copies. Paragraph 6, my lord, if I may invite my lord's kind attention to paragraph 6. Just at Placetum F, my lords will notice in relation to the Punjab Town Improvement Act, my lord, Placetum F says the scheme was notified as has been referred herein before in accordance with provisions of 36 of the Act. Insofar as the publication of the scheme in the newspaper Tribune in 3 consecutive weeks in April 1976, inviting objections till May, is quite in accordance with the provisions of the said section. Not page over, page 759. Page 759.
Next line, Mr. Reddy, where you read.
I'll read it. I'm sorry. Gazette notification published in 3 consecutive weeks was, however, made after the expiry of the period of filing objections against this scheme. This has been the bone of contention on behalf of respondent to and others in this result.
Which was made. Look, on that there is sometimes a dispute. What happens to the Gazette notification if it is to be given retrospective effect, because Gazette normally takes a long time to be notified. On that, there are decisions in your favor. But absence of Gazette notifications, decisions
only
are
one line next page.
Entry in the press and all that, BK Srinivasan and all that.
That was always the issue. But
only one para on the next page. Judgment page 759.
That's a matter of remand. Why should be?
Yes, my lord. And 5.
But then may make one request. Because, my lord, there's a functioning school which last 6 years have been operating. Since the matter is remanded, lordships may kindly direct the authorities to dispose it of.
Okay, we are not inclined to interfere with the impugned judgment, and hence, especially petition is dismissed. However, as an order, moreover, an order of remand has been passed.
Yes.
We hope and trust that the matter would be taken up for hearing expeditions.
Highly obliged.
Only one final request in public interest. Running school, 150 students
That's
in the middle of academic.
That will be examined by the
No,
authority.
your lordships may only direct, my lord, that the school's functioning should not be disturbed. That's all.
No, that's fine.
But because April, the students go for examination.
No, don't worry. That will never be. Nobody will like the school to close down. Neither do you want, neither the other side.
Grateful.
Please, my lords.
Please, my lords, we are being led by a senior counsel. He's on his legs in another court. If we can short pass over. All right, Lordship. Thank you.
Yes, please.
But here the state is praying for some indulgence, my lord. We were required to, my lord, take a decision. Lord, last opportunity lordships had given by the last order. But, my lord, deliberations are going on, my lord. It's a communally sensitive. Yeah.
Ask for time repeatedly. Like,
My lord, the cabinet subcommittee has been meeting.
Since when has the decision not been taken?
Since the 5th of September, your lordships directed, my lord. Lordship sees the last order of 3rd of September.
No, but before that also the committee.
Yes, my lord. Since, Lord, in fact, since March, my lord.
March of?
24, my lord.
Then it's almost a year.
Yes, my lord.
That's
not deliberate. No, bow down, my lord. But, my lord, this is
Take
a
the
regular
decision
case
within
for
the next
both
6
Hindu.
weeks, failing which you pay costs. Not March, January the order. January, you pay, take the decision within the next 6 weeks, or we can make it 8 weeks, but if you don't pay, then you pay costs.
This may make it 8 weeks, my lord.
We extend the time.
But a decision will be taken, my lord, which will be probably, my lord, acceptable to all, my lord. Here, in fact, as of now, there is
Whatever it is, there are some difficult issues you have to decide.
Lord,
You have
as
to
of
decide.
now, my lord, the shrine, my lord, Hindus are, my lord, being led by a Hindu, my lord's pujari. And my lord, as far as the Muslims are concerned, there is a mujawar, my lord, who takes care of the Muslim rituals. And this is a revered place, my lord.
Whatever it is.
Yes,
but
my lord.
you
So
know, some-
therefore, as
some
of now, there is
decisions
no problem.
Some decisions are difficult. We are not saying they're not difficult, but there was something already in play earlier.
Yes, my lord. Pursuant to the directions of the High Court itself, a decision was taken that as far as the Hindu devotees are concerned, they'll
Extend the time
Yes, my lord.
for taking of decision in terms of order dated.
My lord, so 3rd of September, my lord.
3rd of September
24.
2024.
The last opportunity was given.
No, first order.
The first order, my lord, is, my lord, 7th of March 24.
No, 25th of January.
My lord, 7th of March.
25th of
25th of January.
I'm grateful.
Not March.
25th of January. I bowed down.
No, we extend the time for in term. Let's strike the whole thing. By order dated 25th of January 2024, the matter was adjourned to enable the state of Karnataka to submit the report through decision on the dispute. So thereafter, the matter has been repeatedly adjourned from time to time. First off, we grant last opportunity of 8 weeks to the state of Karnataka to deliberate and take the decision and place the same on record, failing which the respondent state of Karnataka would be liable to pay costs, which would be determined by the court. List in the week commencing, when are 18 weeks over? Exactly the same week.
7th of.
And week commencing 17th of March. So make it 24th of March 2025.
Extremely grateful for the indulgence.
I think 18 I'm seeking a pass-over. 18 blood they have already implemented. Sorry, it's 19.
They want to pass over.
So he's not in it, he's in.
I was in 19, I'm so sorry.
Oh. 18
they've implemented the order, so they've already paid me, and they'll pay me by March, they'll pay the whole of it.
Is it subject to the outcome of the appeal?
In any case, it will be subject to outcome.
Pardon?
18, they've already paid me, and the consequential order was passed in September. They've paid me in 2 installments by March.
What is the legal issue involved?
Lord, the issue is with regard to Lord a tariff which has been fixed for the purposes of the generating company, as to whether a dedicated transmission line which was to be built by the state, whether I should be given O&M expenses for that or not, because ultimately I built the dedicated transmission line. So obviously, since I built it, I had to. So the MPRC had held that no, I'm not entitled to O&M expenses because it is not in the regulation. If the line was to be built by them, in which I have built, obviously not the expenses for maintaining it.
Who's are paying for the other side? Solicitors.
Mr. Mehta used to appear in the last day. But this actually.
So the only issue is with regard to the dedicated
and the other issue with regard to tax also.
Pardon?
There is another issue with regard to tax also, whether not the tax of the standalone entities to be taken or the group companies to be taken, for which there is already a judgment of Tata Power, which has been held, which has been followed by the tribunal, which is unchallenged.
What has been held in that judgment?
In the Tata Power judgment, it has been held not that every licensed business has to be seen separately. So if you are making profit here, then whatever tax set off you are entitled to will not be adjusted against losses made by the group company somewhere else. So they have simply followed an earlier judgment. So your lordships have held that if it's a Would your lordship consider having?
We see, let it
I-
come 2 o'clock.
No, nobody is making a request.
I know that, but that's, we normally grant.
I will be stuck, but would your lordship?
If there's some problem, we'll accommodate.
Very well.
In 19, I seek a pass.
Very well.
So item 20, I'm taking a pass over.
Oh. Is it 10 o'clock? It was small.
Apologies, Manoj. We're seeking a passover on behalf of Mrs. Astha Tyagi. She represents Argon in this.
Just 1 minute, just 1 minute.
Filed their counters in the matter.
This will probably go with the other matter, the 5 judges.
To the 3 judge, yes, Manoj.
3 judges bench.
Yes.
Which is that matter?
The Karnataka matter?
List with, give us the details.
Yes, Manoj, I'll just write it down and give it.
You have the copy with you or some
The
order?
copy I don't have, I'll write the numbers.
Please give the number.
Yes, Manoj.
List along with also.
Well, Manoj.
Interim order to cut.
Manoj,
Interim order to cut.
yes, Manoj, would you please be directed to file their replies?
Well, they have not filed reply.
No, none of the parties have filed their replies so far.
In the meanwhile, parties will complete the pleadings.
Obliged.
It's 22, may I only request for a passover? Mr. Singh is leading us.
My lords, in item
He's on his
22,
legs in court 13.
my lords, in item 22, I appear for the Pollution Control Board members. The whole case is based on a fact that whether a gap analysis was required or not, as mandated by a regulation, which by a notification which was amended. Now, my lords, pursuant or subsequent to the impugned judgment, the gap analysis actually being done, that report is finalized. In fact, Pollution Control Board will need 15 days because there's an action taken that will be taken, which will be passed on the basis of that report. I'm requesting if lordships can have it after 2 or 3 weeks, then I can at least place that gap analysis report, which is in terms of the CPC.
That's been already undertaken.
That was undertaken. In fact, although
appealing for Central Pollution Control.
No, I'm appealing for the Andhra Pradesh Pollution Control Board, which was being mandated by the CPCB guideline.
In fact, while issuing, I have no difficulty.
Because that will give a clarity.
At the request of Council appealing for Andhra Pradesh Pollution Control Board, place for, that's 2 states and placed for time to place on, place for 3 weeks time to place on record the
Gap analysis report.
What?
Gap analysis.
Gap
analysis report.
Gap analysis report. What's the full form of gap?
But we have also.
It's basically just a report to decide, to determine whether a new facility is required or not.
Gap analysis report will. First, a copy of the said report will be furnished to the council for the parties. The list in the week commencing 1st of April 2025.
Well, Leonard Friend may also have to get instructions, because my instructions and we have placed it on record is this gap analysis report which was submitted, which Leonard Friend is referring to, has been rejected because it is.
In fact, that was originally a draft report which they had placed. What happened was this, in this case, what has happened is the NGT has relied on a circular, which was in 2016 that a gap analysis had to be done. Difficulty was the CPCB did not give the actual factors or the methodology on which such an analysis had to be done. That methodology was only communicated to us in 2023. Before that, we had started on the work of gap analysis. That draft report came. We had sent it back. We sent back the draft report back to the actual maker, saying that now you please make it in terms of the CPCB guidelines and the methodology which they have referred. So the report which I am now going to file is strictly in accordance with the CPCB guideline.
For the date, I just take one, if your lordship permit me 1 minute, my lord. My lord, this gap report is required if you need allotment of land from the government. If a private enterprise buys land and the clearance of the environment incinerator is on the site where you are locating it, the site stood approved. I am a private enterprise who has come up with the treatment, my lord, of the waste beforehand, and I fulfill the requirement of, my lord, laid down by the CPCB. It can't be, my lord, something is already placed in advance for protecting environment. Permission is granted, permission is withdrawn because of the competitor. He is my competitor. He doesn't want me to come there. I fulfill both the requirements and I don't need land allotment. Gap is not what is the meaning of gap is that if the located incinerator which is existing, if it is meeting the requirement of the area, government should not waste more land for more incinerator. Therefore, if there is a gap, that is now the requirement has increased, that will be assessed and then the government will make further allotment. But if the gap already shows otherwise, that there is a requirement and the land is not to be obtained from the government, it is created and the site is approved.
See that, Mr.
What should we have it early, Mullah? It's live.
No.
Mullah, there is a gap of more than 20,000 beds and this incinerator is ready.
We are 130 kilometers away.
And that incinerator is 130 kilometers away. So we are now not stopping the incinerator.
Okay, we'll give you an early date. We commencing 17th of March 2025.
We struggle, Manoj, for setting up the pollution treatment plant. Here it is ready and it is.
As per the gap report, what is the situation?
Well, this instruction came yesterday. In fact, I had checked with them. They said they were not able to communicate to me. Because the concerned officer has to do it. But as far as the merits is concerned,
So the policy is on record.
But there are a few other
Manoj, in fact, on the aspect which my learned senior has said, in fact, even the stand of the Pollution Control Board, I also represent the State Environmental Impact Assessment Body, which in fact granted the environment clearance. Gap analysis, as he rightly pointed out, is only a methodology which was to be adopted to decide whether you need a particular unit, a new unit or not in a given area.
Correct.
That's a fact. That is the actual matter.
No, what he is saying, what he is arguing is this. That means that's only a study to know whether additional requirement is there, but nowhere gap requirement is essential for.
No,
or can we bar? Can we bar set up a competition?
Even when the environment clearance was granted, yes.
If I were to obtain the government land, the gap has already reached 10,000 bed one incinerator. Today they are 27,000.
In fact, just to place it on record, even when they applied for the environment,
Gap cannot become a source for monopoly.
Correct, my lords. But apart from that, even in this case, and this is something which is a matter of record, when they had applied initially for environment clearance, the SIA, that State Environment Impact Assessment Authority, had asked the applicant to get an in-principle permission from the APPCB. Because this confusion was there on the methodology, the Pollution Control Board had asked the DMO as well as the environmental officer to do a study to figure out whether a new treatment plant was required or not. That report was obtained that yes, it is a requirement. Then an in-principle permission was given by the Pollution Control Board to the appellant, which was then placed before the state as a stand, even without filing a counter. Gap analysis cannot be a basis for an environment clearance because that is a separate footing. Gap analysis only.
No, that will be too much. If we say you can't give environmental clearance till the.
In fact, unfortunately, the objection was not raised by the Pollution Control Board in the NGT. But the fact is, it is a fact. He is existing there. It's
giving a shot at it.
Mr.
Maninder Singh, we are not deciding the issue.
No, I'm just high flagging that in such matters, my lord, where your lordship would be required to lay down the law, my lord, where if somebody is coming in advance to treat the future pollution, it can never be stopped, my lord, with utmost respect. And when there is no government investment,
Mr. Maninder Singh,
we'll come back, my lord. Your lordship has given us early dates. Grateful.
We bring it to his notice only. Wait, please, Your Lordship.
Yes, please.
No, this matter arises under the MMDR Act and it relates to a competing claim, my lords, between JSW Limited and Rudra Gowda Mining Company Limited for a mining lease in respect of the same area in Karnataka. Before I proceed further, my lords, I think it is my duty to just point out that in some of these matters, my Lord Justice.
Oh, yes, yes, yes. Sorry, thank you.
I have no problem at all. I have
No, yesterday I had noticed before and mentioned to my colleague.
But I want to make it abundantly clear. I have no problem. I have
No, let it go before.
We also have no objection on this because I'm the.
No. I also saw the appearance. Probably in 23.2 or 3.
Yeah, it's a big batch of matters.
We listed before a page of Honorable Mr. Justice M.M. Sundaresh, being presided by Honorable Mr. Justice M.M. Sundaresh in the week commencing 10th of February 2025.
Very well. Very grateful.
Who's appearing for the petitioner?
I'm seeking an adjournment in this matter, but the AOR has just recently been.
Please, Manoj. I've just put in my appearance in this matter. The previous line at AOR has been designated. As I seek a small accommodation, Manoj.
What's the issue?
Manoj, I've just received the file, Manoj. It's a mining dispute.
What is the issue?
Because there was a demand notice for illegal mining of granite. Instead of going in appeal, there's an appellate provision. They went to the High Court challenging the virus of the particular appellate provision, as well as the demand notice. The High Court has merely said that you avail the provisions of the
deposit condition.
That the condition under the rules is 100%, but the High Court has granted them 50%.
50%. What is there in this special petition? Is a stay operating in his favor?
No, my lord, he has deposited the amount here.
He's deposited the amount here. Let him go up in appeal then. Take instructions, go up in appeal.
My lord, I'll take instructions, my lord. Please.
What is there? We are passing it over, come at 2 o'clock. There's nothing left.
My lords, please.
Just take instructions, go up in appeal now. You deposited the amount, nothing is left. No, that doesn't mean. But there are number of judgments upholding the pre-deposit conditions, but we always excise, the red courts always excise the discretion to waive that condition.
That challenge was given up before the High Court and the High Court has recorded it.
Please take instructions, go up in appeal now.
Very great.
Yes, please.
It's a reversing judgment, my lords. In fact, that first appellate court reversed the trial court judgment.
What's the issue?
The issue is, my lords, in very brief. My lords, as far as I am concerned, my lord, I am an auction purchaser, subsequent auction purchaser. The respondent number 1 was allotted, my lords, a plot by the Raipur Development Authority in 1988. Now, the terms and conditions of the, my lords, the auction which are admitted, they required, my lord, 10% of the amount, 30% of the amount to be deposited immediately, my lords, or the hammer falls.
Sure.
And within 15 days, my lords, the remaining balance has to be paid. Now, my lord, he did not comply with any of these conditions, my lords. He only paid 10% in the beginning, my lords. According to RDA, a number of notices were given to him, my lords, for the payment of the balance. He eventually, my lord, ended up paying only 30%, my lords, and did not pay the remaining balance. Consequently, my lord, the Raipur Development Authority cancelled the, my lord, the allotment of the plot in his favor. My lords, after a year and a half, my lord, he filed a suit for declaration simpliciter for cancellation, challenging the cancellation, my lords. He applied for injunction, my lord, the injunction was refused. And thereafter, my lord, after the refusal of the injunction, the plot was put to, my lords, a fresh auction. Now, I am, my lords, the auction purchaser, my lords. I did not have any notice, my lords. I purchased it, my lords.
The lease has been executed way back in 1996, my lord, in my favor. Petition has also been delivered to me, my lords, in 1996. He did not challenge, my lord, the subsequent allotment in my favor, my lords. He did not ask for the petition also, my lords. The trial court dismissed the suit, my lords, on the ground holding that you are non-compliant of the conditions of the auction. His plea was that he ought to have been given a notice before the final cancellation of the allotment. Or, my lord, the trial court took the view that it is implicit in the terms of the conditions of the auction that you will comply with the terms and conditions. There is a time limit, my lord. 15 days is the maximum time for payment of the amount which it is.
Who's appearing for the opposite side?
I am appearing for the respondent.
Yes, please. What do you say?
No, there is a
question of giving notice in case of non-compliance of tender conditions.
no. Actually, there is a clear-cut finding by the appellate court in my favor, upheld by the High Court, that we have filed the suit earlier, and during the pendency of the suit,
Maybe list pendants doesn't mean
auction work
anything.
took place.
Hey, 1 minute, please. List pendants doesn't mean anything at all.
It was a case of list.
When was the first auction? When
It
was
was
the
a
first
case of
auction?
list pendants.
The date is
When was the first auction?
8/12/1988.
8 when?
1988, my lords. 1988. And he deposited, my lord.
8/12/1988 is the first. 8/12/1988
Yes, my lord.
is the first auction.
That
What
is-
was what was the amount?
The total amount, my lord, was 87,450, my lord, the total auction money.
And he had to deposit 25%.
30% of which, my lord, immediately on the fall of the hammer.
So how much is that?
That was about 17,000. About 25,000 roughly, my lord. I'll give the exact amount.
Give us the exact amount.
Yes, plus we'll give. And the remaining 70% was to be deposited within 15 days. That's, my lord, clause 9 of the auction notice.
Which page is that?
My lord, that is page 6.
No, clause 6 also relevant page 7. Clause 6 and 9. Page 7.
Page 7.
Start 6. Page 33, my lord, is page 32 and 33 of the SLP. Clause 6 and 9. And again, clause 5 may also be seen, my lords. The composite is scalable. Clause 5, after the highest bid has been accepted, the person offering the said bid shall be required to immediately deposit 30% of the amount immediately at the counter on the auction value.
So the acceptance was to be there at the date of the auction itself.
Yes, yes.
30% we paid immediately.
Just a minute. Instead, my lord, he deposited only 10%.
Not deposited 50%.
Now 30% is not deposited admittedly. Now the highest bid offered in the auction for a plot will be deemed to be approved bid, but in the case the said final bid is suitable, is not suitable in the opinion of the chairman or the said bid is less than the served price, then chairman can reject the same and can re-auction afresh. However, in case the chairman accepts the highest bid, then the person offering the bid will be required to immediately deposit 30% of the bid immediately, and the money deposited by other bidders shall be returned. After the chairman has accepted and approved the highest bid in auction.
But there's contradiction coming between
there's some, my lord, there is some.
There's contradiction
But when we
between 5 and 36.
when we read, my lord, the entire, but it is his own case, my lord, that his bid was accepted. The person.
When was it accepted?
My lord, there is no separate, my lord's communication of acceptance, my lord, but the
Never
parties.
accepted.
The parties understood that it has been accepted.
First notice was 519.
And I will just tell, my lord, what his case is, my lord, shortly after I read these conditions. The balance amount of auction bid in the office of the authority within 15 days of notifying such acceptance. In this manner, the plot will be transferred. Then 9, my lord, please see, that is important when we read them conjointly. If the successful bidder refuses to buy the plot or fails to deposit the required amount within the prescribed period,
the chairman will be free to quash the auction ex parte and the entire money so deposited will be forfeited. My lord, these are the relevant conditions. Now, my lords, the RDA will tell your lordships, my lords, from their records. Notices were given, my lords, notwithstanding my submission that they are not required as such, calling upon him to deposit or comply with his obligations, my lord, which are put under the auction memo. Then, my lords, the various dates notices are there, my lords, which are pages 36 to 42. And 12/10/1990, my lord, the allotment is cancelled.
Yeah, how much amount did he deposit on the date of the auction? When was the date of acceptance? Please tell us those relevant dates.
So, my lord, the date of acceptance, my lord, it seems, my lord, that was on the date of the auction itself.
No, clause 6 says it will be on acceptance by the vice chairman.
By the chairman.
By the chairman, sorry. So what's the date on which the chairman accepted that?
Never accepted, Milos, never.
No, but then but his case, my lord, if I can, pleading the plaintiff says so, that it
Where is this plaint?
Plaint, my lord, kindly have the plaint.
So there is a deemed acceptance of the highest bidder unless rejected.
Unless rejected.
Page 40.
Is a contradiction.
Page 48, my lords. And it's very interesting, your lordship will see that the plaint, he did not deposit it. Para 6 of the plaint at page 49. His case is so that is not the case, my lord. The chairman did not think. Now, please see the plaint, my lord. So, lordship, that's very. He does not plead, my lord, that the bid was not accepted. That's not his case. That chairman did not accept his bid, or that acceptance was at any point subsequent. Or, my lord, that notice was required to be given to him, which was not given. If your lordships will see page 49 of the paper book, page 49, his plaint, in para 4.
How much amount have you deposited?
Well, let's see, my total amount, my lord, is.
Full amount, my lord. There is a lease deed. I beg to appear, my lord. I'm sorry, I was actually on my legs before court 6 in item 11, my lord.
Yes, a lease deed executed.
But yes, my lord, I appear for the development authority.
Only 30%, both the parties.
May I answer? There is a lease deed which has been executed in favor of the SLP petitioner argued by Mr. Malod Srivastava.
So,
5/1/1989 is the crucial date. That's the date on which, my lord, we say that we issued a notice to him calling upon, my lord, to deposit the entire amount.
What's the date of that?
Yes, 5/1/1989 is Exhibit D to demand notice. I must also at the outset say that he purports to deny this demand notice. But in a moment, my lord, I will show to your lordship as to how it is followed. My lord, the conditions of the tender, my lord, are at page number 31. Condition number 6. May I place that condition? The highest bid offered in the auction for a plot will be deemed to be approved. So there is a deeming approval to the bid of one of the present respondent, the plaintiff. But in case the said final bid is not suitable in the opinion of the chairman, or the said bid is less than the reserved price, then the chairman can reject the same and can order re-auction afresh on the next day. However, in case the chairman accepts the highest bid, so that, my lord, he is trying to take advantage of this portion. Otherwise, he had to deposit, his bid was accepted there and there, my lord, on the date of the auction, the entire amount. However, in case the chairman accepts the highest bid, then the person offering that bid will be required to immediately deposit 30% of the bid immediately, and the money deposited by the other bidder shall be returned to them. After the chairman has accepted and approved the highest bid in the auction, the person offering that bid shall deposit the balance amount of auction.
Actually, there is a contradiction coming between 5 and 6 because of that clause. This says you have to deposit. One you says deemed acceptance, then you also say 30%.
It's
Or
not
in
very
case
happily
except
drafted.
for highest
But
bid,
my
the
lord,
person
I tell
offering
you,
will
lordship,
pay.
therefore everything turns on the facts of the case, my lord. I appreciate what I bow down to what falls from your lordships, my lord.
The lordship may pass the equitable terms for in the interest of each and every
My
party.
lord,
It says this must be a translation from the Hindi document.
Or is it English?
Yes.
Equitable terms and conditions may be put to the parties below. This is the old
On
litigation.
5-1 when we issue a notice, my lord, that's admitted. After that, he deposits the balance 20%. By that notice, we call upon him saying that your bid is accepted in full. Please deposit the entire amount. He chooses only to deposit 20%. This is a circumstance independently and equivocally pointing out to the fact of his
And he was
knowledge.
yet served, was served.
Otherwise, my lord, how does he deposit? Please see those two dates, my lord. The auction is held on 8/12/1988.
Page 10 finding is no notice has been received.
Wait for your turn, Mr.
I'm
Gupta.
sorry.
I will only, since my learned senior friend in age, I will only, with folded hands, request him to permit me to complete. But the narration of date is auction is held on 8/12/1988. 5/1/89, exhibited document, exhibited, my lord, at exhibit D2, calls upon him to make balance entire payment. Now, the admitted case of the party is that he deposits only balance 20%, 14,450. After receipt of this, on 14,150, and lordship will find that date at.
This is in addition to 8,800 which he had deposited.
No, he had deposited 7,100. 1,000 rupees was a condition to
7,000?
the bid.
1,000?
7,100 was deposited.
Yes.
On the date of the auction.
Yes.
But before participating in the auction, every person who wished to participate had to deposit 1,000 rupees.
Okay.
So that is how 8,100. That's kind of a security deposit for the purpose. At the end, it will be adjusted, my lord, in the final price. So, my lord, 5/1/89 at page 57 on 16 January 89, my lord, he was given, my lord, time to deposit. He deposits it on 16/1/1989, an amount of 14,150.
So that shows probably he was aware of the.
Well, now, most important is his own evidence. His own evidence says that why, the question was put, why did you not deposit the amount? He says, I did not deposit the amount because the Raipur Development Authority did not develop the land. And that is why I did not. He didn't say I never received any intimation about auction being confirmed. But please see, probably page numbers of the file that your lordships have in mind.
I should be excused. No, he is arguing against the finding by the High Court. This is not a.
Well, on basis of evidence, the Supreme. But the finding of the
judgment specifically page 10 giving a particular finding.
Wait for your turn, please. Wait for your turn.
Well, please come to 17. Well, if your lordship will please have file of SLP 30903. That's the Development Authority where all documents are on record. Is 25.3. 2. I'm so sorry. 25.2. 30903. Please see page 34 of that, my lord.
Yes.
Page 34. This is the notice of the authority. 5/1/1989, addressed to him. Plot number 73 at measuring 795 square feet was allotted to you in the auction held on 8/12/88, which you had offered bid at the rate of 89 per square feet for the above plot. And thereafter, you had deposited a sum of 7,000 being 10% of the auction price, and the auction venue itself with a receipt number 812. Or if the bid was not accepted, there was no question of firstly accepting even this 10% or this depositing 10% if he fell within later part of clause 6. Clause 6 of the conditions of the auction clearly stipulates that the successful bidder will be required to deposit the entire money of auction bid within period of 15 days after his bid has been approved and notice has been given to him in that regard. You are accordingly informed that you should deposit balance amount of 63,655.60 up to 16/1/1989 in this office in cash or through bank after adjusting 10% which has already been deposited by you out of the total amount of the premium of the plot amounting to 70,755. Please note that in your case you fail to deposit the above amount within stipulated period. There, in that event, the allotment of the plot in your favor will be deemed to be cancelled. Entire money deposited by you in this past will be forfeited. Now, my lord, he deposits 14,150 on 16/1, and that has been admitted by him at page 57. Page 57 is, my lord, his deposition of PW1, para 1. Last 2 lines.
Yes.
I'm sorry, I may read, my lord, the 4th line. I had deposited a sum of rupees 1,000 before participating. Plot number 73 purchased by me after offering maximum bid of 89 per square feet, and thereafter I deposited 10% of the total auction price. So he admits the fact that, my lord, his bid was the highest. Only then question of 10% deposit comes. Thereafter, I deposited 20% of the auction price, that is 14,150 on 16/1/1989. So it's an admitted position on base of the evidence. Now, my lord, this notice which I read to your lordship's exhibit D2 dated 5/1 is not the only notice. We give him, my lord, 5 other notices: 11/4/89, 11/5/89, 6/3/90.
11/4/89.
That is exhibit D3.
Yes.
11/5/89 exhibit D4.
Yes.
6/3/90 exhibit D5.
6/3/90
exhibit D5. 12/7/90 exhibit D6.
12/7/90
exhibit D6. And final notice, which we cancel the, my lord, agreement or the, my lord, allotment in his favor, exhibit D7 dated 12/10/1990. My lord, as your lordships have seen, is the High Court which, my lord, in one second, I'm so sorry. So sorry. In second appeal, my lord, approves the order of the first appellate authority. The trial court had dismissed the suit. Now, one of the reasons which the High Court says, and I've checked up the, my lord, I had a meeting with the officers, that you have not produced proof of, my lord, these notices having been sent. All of them were sent under UPC, my lord. I have documents to show that they were sent. But I rely upon the plaintiff's own act of depositing that 14,150, because that is much after, my lord, 46 days after the date on which the auction is held. 39 days after which the auction is held. Otherwise, he could not have known that he was required to make a deposit on or before 16/1/1989. But he files the suit. In the suit, he prays for an interim order to restrain auction, which is rejected. The date of rejection is, my lord, 11/3/1992. He files the suit, my lord, on 10/3/1992, 2 days before the auction. So he waits, my lord, even after cancellation. 1.5 years. In the suit, though he knows that there is going to be re-auction, my lord, he seeks a, my lord, relief of setting aside his cancellation. 11/3 interim order is rejected. The auction is held on 12/3, which is brought on record before the trial court. He chooses neither to amend his prayer, to challenge the re-auction proceedings, nor to implead the, my lord, auction purchaser, because this fact is known. We have disclosed it before the court. The lease deed in favor of the successful bidder of the re-auction is executed on 24/10/1996. Now, my lord, another important aspect of the matter, which, my lord, the High Court and the First Appellate Court has missed, is that at best, my lord, when he asked for when he asked for cancellation of the, by setting aside of the cancellation notice, in fact, he was asking for, my lord, a specific performance of the contract entered. My lord, your lordships are aware that provisions both of section 16 and 20 of the specific relief act would have, my lord, a bearing on the matter, because the plaintiff had to ever and prove that he was ready and willing to perform. His own act shows that, my lord, these conditions are not satisfied. And secondly, my lord, the trial court, having exercised its discretion in dismissing the suit, the first appellate court had to have, my lord, cogent reasons, because your lordship will recall the word used in section 20 that
both the courts had dismissed the suit.
Well, the trial court dismissed the suit, first appellate court allowed the suit, and second appeal, my lord, confirms that.
It allowed it on the what ground that?
Well, on the ground that these notices were never served.
Because you were not able to prove those notices.
Yes, but, my lord, the fact that, my lord, independent fact that, my lord, this was completely.
Yes, Mr. Gupta, what do you say?
Please kindly see page 10, first of all, the impugned judgment passed by the High Court. My learned friend is arguing without disclosing what is the concurrent finding by the first appellate court being the final court as the finding of fact is concerned.
We are
Upheld by the High
aware
Court.
of that. Mr. Gupta, we are aware of when we can interfere with the question finding of
That's
fact.
true. But can you see?
Don't remind us of that. Come to the meat of the matter. Come to the core of the matter.
I will request your lordships to.
Mr. Gupta, we are aware of the principles of perverse finding.
We are ready to pay the amount. We are ready to pay the amount what Sir Lordship will ask us. But let it be equitable. Let it be equitable.
Mr. Gupta, please, let's not beat around the bush. Come to the core matter. Come to the core
Page
issue.
10.
When did you file the suit, please? When did you file the suit?
It was on 10th March 92.
92 or 95?
92. It was page 16. Page 16 of the.
And was it a suit for specific performance? Was it a suit for specific performance?
Because I initially filed suit for temporary injunction. Hello.
Yes.
Kindly see page 16. It is, everything is mentioned there.
Was it a suit for specific performance?
No, actually, by that time, the appellate court allowed my prayer. Kindly see page 16 for a moment.
60.
Impugned judgment passed by the High Court. I am actually taking the matter, this is SLP 23881.
Which paragraph?
There are 4 SLPs. SLP.
Please tell us which one are you relying upon? Which paragraph are you relying upon?
Paragraph 18 Milos.
Okay.
Paragraph 18.
So really the issue was with regard to service of the notice.
Yes. Can you see page 10? Page 10. The paragraph is 11. Paragraph 11 of the High Court judgment. Kindly just bear with me only paragraph 11 only.
Yes.
From the it is a specific case, last 4 lines. It is a specific case of defendant. Issue notice to the plaintiff on.
That's it. They don't find any documents to show so. But tell me one thing. Once you've deposited that amount, will you not go and ask?
Yes.
Is that not a human conduct? You'll go and ask for what has happened to my plot. What has happened to that? And it is not one plot which is sold. Several plots are sold over there.
No.
Number 2.
Their main contention.
30% within the last day.
Look, both the parties reported only 30%. Look, it is a government property. Your lordship may have the equity
sorry,
part.
Mr. Gupta. Sorry. Leave granted.
For a moment, just kindly have a.
That's all, Mr. Gupta.
Kindly allow me only 1 or 2 minutes,
Having heard, that's all, Mr. Gupta. We've heard that it asks for the parties.
Some equity may be imparted to the parties, Milos.
Equity cannot be put in. You have not paid the amount.
No. Both the parties who are contesting, how they can be given after 30 years at the rate of which is prevailing market rate now.
Mr. Gupta, there is a lease deed executed. I asked that question for that purpose only.
No, they have only paid 30%.
No. Sorry.
24/10/96.
They only pay, because they hardly paid below 20,000 till date.
That's all, Mr. Gupta, we have understood. Deep granted.
Then they should be also burdened with the public money, not to go with the public money like this. Because I am ready to deposit. Whatsoever Lordship will ask me, or kindly refund my amount with interest.
Thank you. You have not
At
asked
least
for that. in your
they have
statement.
forfeited my amount, Milos. They should refund my amount with interest.
Correct. You should have asked for that prayer.
Milos, some equity, Milos is the
Now, Mr.
142.
Gupta, that's all. Mr. Gupta, we are not dictating the judgment, don't interfere. We are of the opinion that the High Court erred in confirming the judgment of the first appellate court, which had reversed and dismissed the suit for filed by, what is the name of your client, Mr. Gupta?
Dev Kumar.
Dev Kumar.
The present respondent.
Dev Kumar Khimani.
There are two cases below, Gopichand Khamani and Dev Kumar.
Father and
Two plots.
Gopichand Khamani and Dev Kumar Khamani.
73 and 74.
For which page is the plaint?
The plaint in that's at page 43. The prayers are at page 50 of the SLP that I made submission. Page 43. The plaint starts. Civil suit 169-A of 1995.
Yes.
It was filed.
It was amended. So give us the amended plaint.
This is the only prayer. This is the only prayer. My submission was he never amended.
For restraining re-auction of plot number 73 in Indira Commercial Complex at Mandari under the Devnagar scheme on 12/3/1992 and to declare the order cancelling the allotment of the plot to them as illegal. Full stop. Next pen. The facts of the present case exercise show that the said respondent, who are the plaintiffs, had suppressed and concealed facts. Full stop. In the auction held on 8/12/1988, the said respondent within brackets, the plaintiff, the said respondents within bracket plaintiff. And
73 and 74.
There are two plots or two plots?
Two different plots, two different cases, two different civil suits.
24.
That's why there are four SLP, one by state, other is by the other party.
In the auction held on 8/12/1988, the said respondents, being the highest bidders, had deposited rupees 7,100, which is 10% of the bid amount of rupees 87,450.
70,000.
70, no, the bid amounts are different.
70,000.
Yes, in the plot number 73, the bid amount is 70,755.
Okay, I'll have to, let me not go into the figures, I'll dictate it differently. Just read out.
Otherwise, I can give a chart, my lord, indicating plot number. I can do it by.
But then it doesn't help me now.
Yeah.
I want it to be dictated here and now. What's there in this? Why should I even reserve this matter? Or why should I make it KV chart? So simple. I want the figures. How do I dictate it without the figures?
Well, I can.
Okay, we'll dictate it at after 2 o'clock, around 2:30. By the time you get me the figures.
Indicating the dates and, my lord, the amounts.
Yes, please.
They are not father and son. They are not father and son.
No, brothers. They are brothers.
They're not brothers either. Fathers' names are different. Narayan Das Khemani is the father of Gopi Chand. Nainu Mal Khemani is the father of Dev Kumar.
Malad, please see, Malad. Please see both
Look
the
at the
affidavits.
suit.
Malad,
Look at the suits, the planes.
but Gopi Chand Khemani, son of Narayan Das Khemani.
One way to deal with it, I don't go into the facts of
The same Malad has different names. Nainumal Khemani.
This common judgment disposes of the aforestated appeals. Stop. In our opinion, the High Court was, in the impugned judgment, was clearly wrong in affirming the judgment of the first appellate court, which had reversed the judgment and degree of the trial courts, dismissing the suit for dismissing the two suits where plot numbers
72 and 73.
72 and 70.
73 and 74. I have the
73
prices
and
also.
74.
I have options.
In the Indra commercial complex at Pindari under the Devnagar scheme, and to declare cancellation of allotment of the aforesaid plots in their favor as illegal. Next page. The facts are startling and show that the said respondents had not come to the court with clean hands and were guilty of suppressing relevant facts. Full stop. It's an accepted position that the auction of the two plots was held on 8/12/1988, and as per the terms of the auction, the respondents were required to deposit 30% of the paid amount. However, they had only deposited 10% of the paid amount. It is a case of the appellant. What's the name?
Raipur Development Authority.
Of the appellants, including Raipur Development Authority, that they had confirmed, that the chairman had confirmed the auction. Yeah, they confirmed the highest bid given by the respondents and had issued letter dated 5/1/1989, requiring them to deposit the entire bid amount, that is, balance 90%, within 15 days.
16
Before 16/1/1989. By 16/1/1989. This was in conformity with clause 9 of the terms of auction.
Clause 6.
Full stop. It is also accepted position that the respondent deposited 20% of the bid amount and not the 90% as on 16/1/1989, as was required to be done in terms of clause 9 of the auction terms, read with letter dated 5/1/1989. Stop. It is the case of the appellant, Raipur Development Authority, that they had subsequently issued notices, Exhibit P3, dated 11/4/1989, P2, 11/4/1989.
D2 is
11/4. 11/4
is D3.
Okay, D3, not
First was 5/1, which is D2, which asked them to deposit on or before 16.
D3, 11/4/1989, Exhibit D4, 11/5/1989, Exhibit D5, 6/3/1990, and Exhibit D6, 12/7/1990. And thereafter, by Exhibit D7, the allotment was cancelled by notice. Thereafter, the allotment was cancelled by notice Exhibit D7, dated 12/7/19. 12/10/1990.
12/10.
Stop. What is made with the first appellate court and the High Court is a plea in contention of the respondent that they did not receive the said notices. Stop. The appellate Tripod Authority was not all amiss as they did not file letters, did not file the proof of service of the said notices. Stop. There is no doubt lapse on the part of the appellant Tripod Authority in that regard, but this factor alone, in the facts of the present case, would not matter for anyone who has given the bid would have followed up with the authority and ensured that the payment is made. There is a gap between the date of auction on 8/12/1988 and the suit which was filed in 1992. 12/3/1992.
10th.
Pardon?
10th.
Further, the respondents had themselves made payment on 16/1/1989, which is the last day mentioned in the letter dated 5/1/1989. So, in our opinion, it would be fair to draw the conclusion that the respondents were duly served with the notice dated 5/1/1989 and therefore they had made the payment. So, lastly, we may note that the appellants had not filed a suit for specific performance, and what was filed was a suit for stay of auction and for declaration that the cancellation was illegal. The suit as framed was not maintainable and should have been dismissed on this ground alone. Regarding the aforesaid, the appeals are allowed and the impugned judgments are set aside. First result would be that the civil suit numbers dash and dash filed by the respondents would be treated as dismissed.
Gotcha.
There will be no order as to costs.
Very good.
Yes.
Go before another bench. What's the issue in this case?
Mining.
For a bench presided over by Honorable Mr. Justice Nagaratna. In the week commencing 17th of February 2025. 27th,
I have appeared.
same, before Honorable Mr. Justice Bilat F. Dwivedi on 17th of February 2025.
Lordship, item 28, I'm seeking a short pass over, Lordship.
28 or 59? 28. 58 is what? What is the issue?
My lord, issue is regarding condemnation delay. The writ petition was dismissed on a ground of delay. So it's
29.
Please, Lordship. Lords, I'm being led by Mr. Gaurav Agarwal, Lords. I'm only requesting if the matter may be taken up next.
Pardon?
Lords, I'm being led by Mr. Gaurav Agarwal, Lords. He's on his legs in another court, Lords. I'm only requesting if the matter may be taken up next week, Lords.
Appealing from the petitioner.
To be listed before a bench decided over by Justice P.S. Narasimha at the week commencing 7th of February 2025.
Please, 29 minutes.
30.
Wait, please, Lordships. Lord, as far as 30 is concerned, the first matter, I appear for the selfish. This is a matter where the High Court.
What is the issue?
So the issue is only with regard to para 75 to 74 and 75 of the High Court order. I'll just tell you, Lordship, before you open the paper, the High Court purported to, without giving notice to the parties who had succeeded in previous writ petitions and in my case a chamber summons.
Mangroves matter.
That's correct.
So the High Court then sets aside that order which had been confirmed by the Supreme Court, which affects us without hearing us, and on a misconception that that was just an interim order, that the original order was just an interim order. The original order was a detailed order passed common on several writ petitions, notice of motion by MHADA, and two chamber summonses. Mine was one of the chamber summons. It was a common order. It was a final order inter parties pertaining to 9 plots, which are enumerated in that order. I'm only concerned with plot number 9 in that list of 9 plots. So when the PIL comes up for final hearing, the High Court, without noticing the fact that was a final order, takes up only the chamber summons, because my chamber summons number was there, and in para 74 and 75 says that can't operate as a binding precedent. That was an interim order. So even if Supreme Court has dismissed, it's dismissed with a non-speaking order. Therefore, I vary the order. We are aggrieved by that, and that's the short point. We are not questioning.
What was the direction given in that order?
That order said that those 9 plots had already been substantially developed before 1996,
91.
Before 91, and the layout had been sanctioned and developed, and on the Maharashtra Coastal Zone Management Authority, on a direction of the High Court, carried out a survey and found that the mangroves in those cases was separated from the plots in question by an existing road, tar road or a Pakka road built prior to 1991, prior to the CRZ coming into force. And so if I can show your Lordship the original order, the original judgment, and from that your Lordship will see that was absolutely a final order. Now, apart from anything else, if that order is to be varied, it can't be done without giving notice to the parties who had succeeded before the High Court.
Was the variation made?
Yes. So
it was held that you had constructed.
High Court says that nothing in that order will operate.
As per the findings recorded by the impugned judgment, now your construction was not complete by that date?
No, so certain constructions are not complete. We have sanctioned plans. Part is built, part is not built. The High Court says that order will not operate at all. And our final judgment. So if your Lordships kindly just see the original judgment. The original judgment was this 29th July 2015, which your Lordship will find at page 250. So if I can just tell your Lordship, there was in 2005 an interim order of the High Court in this PIL saying that any mangrove of 1,000 square meters with a buffer zone of 50 meters should be preserved. That was an interim order prior to any statutory sanction with regard to.
250 is the order of division bench of the Bombay High Court.
That's right. That is the order passed inter alia on my chamber summons as well as various writ petitions.
So this order it is held is not a binding order.
That's what the final judgment.
Yes,
the final judgment can override the interim order.
This was not an interim order. That's the point. This was a final order inter parties. I'm not concerned with how this with the observations in para 74 and 75 for other parties. I'm concerned with the 9 plots vis-a-vis whom this was a final order. We are only.
You're raising the plea that this order will operate as res judicata.
Res judicata. I'm not concerned with the binding precedent. The High Court mixed up with respect, without meeting any disrespect, the question of precedent and res judicata. This is res judicata between parties. That's all, and that's the short point. And even the PIL petitioner has filed an affidavit before your Lordship saying that we don't dispute this, that this order is not, it was not to affect those 9 plots. So I have only 4 points to make. Number one.
No, one sec. Before you make your point, unless you want to make the point in my favor.
If you are not making the point in my favor, then allow me to.
If he's saying something in your favor, still you'll object?
No. I said if you're making a point in my favor, then by all means, let's go ahead. My worry always is that when someone says, when a PIL petitioner says, I want to make a small point, the point might be just to pull the rug from under my feet altogether and leave me on the floor.
Do not allow that. Yes,
Your Lordships have already clarified that this matter is confined only to para 74 and 75 of the impugned order. That's number one. Number two, we have filed an affidavit, as Mr. Singh is saying. We have no difficulty provided it is confined to these petitioners only. Lastly, the compliances which have been ordered should be ensured. Those compliances are, as the High Court says, these plots only must be on the landward side, and there are compliances in the permissions which have been granted to them earlier. Lordship may just direct that those have to be strictly complied with.
Okay.
Otherwise, we have no other.
We'll keep it on board. We'll go through the file carefully because we have to allow the appeal. We'll go through, we have understood what you are saying.
Yes, Madam.
One, you are saying that you are accepting that this earlier order would be applicable.
Because my
the
SLP
compliances should be made by the appellants.
Yes.
The statutory compliances should be made.
That order itself has a list of compliances. The order which is in my favor
And
comes
number
with its
three,
conditions.
that this earlier order will not be treated as a precedent as far as other cases is concerned.
And not only that, and
But normally, there's one catch in this argument. Normally, a judgment of the High Court earlier in point of is a precedent in other cases, even if not resident case.
yes, no, that can only be answered simply. 9 of them went to the High Court and got.
No. But won't the earlier judgment?
Because the judgment encompasses many things. We are only concerned with para 74 and 75.
We just go through the judgment because
Yes.
we have to allow the appeal. We just go through the judgment. We speak. Are there any other appeals also?
Yes, Lordship. Lordship, there is the appeal by the state of.
That's with regard to the merits of the second judgment. That is
Yes,
with regard to the
regards
merits
to
of
the main impugned judgment, we just want certain clarification about direction 1, 3, and 4. That I will
I'm not sure if notice has formally been issued.
Yes,
that
is independent.
Only respect of para 74 and 75.
No, the 74, 75 is very limited.
First matter.
1 minute, please. As far as the CU Singh's matter or paragraph 74, 75 is concerned, it's a very limited issue.
That's correct.
But as far as the other cases is concerned, it can be.
To 74, 75. I'm just adding one more point. The High Court has gone wrong. If the High Court observes that the CAZ treated MP, when sanction was granted by the Union of India, MOEF, they have put this condition of buffer zone of 50 meters if a mangrove is of 1,000 meters or more. There is a clarification of 2000 issued by MOEF itself that if there is a road between the mangroves and the landward side, and if a development is on the landward side, then this condition will not operate. So mangrove side only will be affected.
We've annexed that additional document.
Just check up on that also. Second part.
I've annexed that.
Misconstrued that.
I'm only
What you are saying is, if there is a road between the mangroves and the building on the land side,
Development was permitted.
then in
We
that
also
case,
sanctioned.
but there the 50-meter buffer zone will not apply.
No, I'll just read the clarification. It says buffer around mangroves. The 50-meter buffer zone around mangroves of area of 1,000 square meters and above will not be required on the landward side, provided the road abutting such mangroves was constructed prior to February 1991. So that is why the High Court got the MCZMA, the Maharashtra Coastal Zone Management Authority, and the Municipal Corporation to a survey and to file an affidavit saying that
Remain on board next week.
Very well. But can I just request them to give me a
To
copy
remain
of
on
the
board.
SLPs?
Not taken up for hearing, to remain on board.
These other SLPs were not, your Lordships are not formally issued notice.
We'll see. We'll see.
May I just request my learned friends to give me a copy of the SLP?
We will provide. The last order.
Give him a copy of the SLPs. Yes. Please give him a copy of the SLPs.
Yes. Apart from that, this Mr. Joshi's and Mr. Sachin's.
So please give a copy of the SLPs. We'll start with the passover matters and the matters which were next matters and the passover matters.
No, then just, I'm so sorry, in item 31, the very next matter, there are 3 matters. In one of them, SEBI is requesting time. I'm in the first matter, but
I don't think we'll reach 31.
It's the very next matter.
No, there are admission matters. There are fresh admission matters, a lot of passovers.
I'm sorry,
We normally take the fresh admission matters and passover matters at 2 o'clock. So those will be taken up. I don't think.
In case it reaches, then we may request time
There's
for
an item 38 before your Lordships where the Attorney General was to seek instructions concerning those set of matters that can the Consumer Court be presided over by just one judge or a non-judicial member at all.
We'll take it up.
Today,
Not this week. Not this week. Maybe next week.
Next week, my lord. Yes, because that's an important thing for your Lordships kind of
next week, Monday.
No, probably it'll come up next week. It'll remain on board. That's all.
That item 30 can be higher on board.
They're following the same system. They'll come up on next Tuesday. They remain on board. Nothing gets delivered.
Next Tuesday, the holiday.
Item 35.
I may be permitted to appear in-
Nothing is.
Your lordships are saying it will come next week? Item
Next week, probably, I don't know, because next week.
Next Tuesday, the holiday, my lord.
Next week, we are working on Wednesday, Thursdays and Fridays.
Tuesday.
May not
Item
come up.
35.
I may be permitted to give appearance on time.
for the delay in sitting.
Just, may I note, sir? 33, last order was to say that it will come in the first 20 matters.
Which part?
33. 33 will come in the first 20 matters. Last time.
What is the issue?
It's CIRP notes.
Pardon? Okay. My brother will not be.
In fact, that's the second thing we wanted to highlight.
33. Yeah, I have appeared in the IFCA, I think.
That's Videocon CIRP. That order, can you just ask it? That's the second reason
why
why
you say to be listed before a bench. Before the bench presided over by Honorable Mr. Justice. Sigma. So.
Over the page.
What is the issue?
No, it's a CIRP, sir. Resolution plan approved by the NCLT, but NCLAT reverses saying that the COC says they want to reconsider after approval by everybody.
Justice P.S. Nasim.
Very good. In fact, argued twice, not fully. Very
43, my brother.
Well, just, I'm so sorry, one other request, can be some indicated about on top
in the week commencing 10th of February 2025.
Very good. Very good.
Your Lordship, the short. Your Lordship, the short point public interest, what happened was, Your Lordship, because of a suppression of Your Lordship's own order in petition 1317 of 2023, the Allahabad High Court has effectively granted relief to two petitioners. Lordship. Your Lordship.
Dismiss that
In the matter, the only short issue is that two petitioners similarly placed as me were also part of the writ.
No, but that was wrong.
They've got relief by the Allahabad High Court.
No, but we have asked you to dismiss the writ petition.
But that's because the interim order in my favor was suppressed by the state.
Sorry. Once we have dismissed the writ petition,
Lordship, then I can at least get liberty to approach the Allahabad High Court, Lordship, because that again happened.
No. You want to withdraw? You are welcome to withdraw. That's your wish.
Because 6 months the tribunal.
No, please, that will not be. That will not be. That will not be. That's for the petitioner seeks permission to withdraw. That's especially. We have the statement, especially petitioners dismissed.
Item 44, Lordship, can you see the office report? Two matters.
Other two.
Other two matters were listed before my Lord Justice Oak yesterday. He directed all three matters to be listed after 2 weeks.
15th January, the computer is showing.
That's a wrong date. The date given was 24th January.
That's correct, my Lord. I appear for the respondent
to listed along with criminal appeal number. Civil appeal number
46 of 25 and 117 of 25.
46 of 25 and 117 of 25 titled. Give the names.
24 January.
Before the bench presided over by Honorable Mr. Justice ASO.
Deeply obliged, my Lord.
This matter will go before another bench. As one of us is unable to hear this matter, will be listed before a bench presided over by Honorable Mr. Justice Miss Justice P.V. Nagaratnam in the week commencing 27th of January 2025.
Yes, my Lord.
Is there any other similar writ pending in the Patna High Court?
Yes, my Lord.
Is there any other similar writ pending in the Patna High Court?
No, my Lord.
How can it be? I think this must be pending. It must be. This issue must have been raised by somebody already.
No, my Lord. On the issues which are filed here, my Lord. On the same issue.
But go before the Patna High Court normally.
My Lord, there is a violation of the fundamental right.
We understand that. But
My lord,
repayment of 2 to 6 is also.
the entire nation has seen how
Look,
the Bihar police is brutally lathi charging on the.
Please, we are not saying that you don't have a case or you don't have a merits in the case or notice should not be issued. All that we are saying is go before the Patna High Court.
My lord, there is a judgment of this honorable court, my lord, in case of Jagisa Arora, my lord, which says that in case of the violation of Article 19 and 21, that this court,
We are not saying anything on that. In fact, let me put it, you are also raising statutory rights also, but we have the discretion and ask you to go to the Patna High Court.
My lord, with regard to one of the prayer, my lord, because nowadays this has become the routine manner, the paper leaking here and there, my lord.
We can't become the court of the first instance. If Supreme Court is going to be a lot of
prayer.
Look, I understand you feel very strongly about what is the issue. We appreciate that.
With regard to the
but then we can't become the court of the first instance.
My lord, the Patna High Court has no jurisdiction with regard to the one of the prayer, my lord.
What prayer?
My lord, 1 minute, my lord. With regard to the prayer number F, my lord, as page number 27, my lord. Direct the respondent number 2 to constitute a body headed by the retired.
They can do it. They can do it. Right on.
My lord, it is humble request, my lord.
We feel that it will be appropriate and more expeditious if the petitioner approaches the High Court of Patna by way of petition under Article 2 to 6 of the Constitution of India.
My lord, it is a humble request, my lord. Because the entire nation has seen, my lord, how the Bihar police has brutally lathi charged on the peaceful protester, my lord.
And therefore refuse to entertain the present petition, leaving it open to the petitioner to approach the said jurisdictional high court. Recording the aforesaid, without making any comments either way on the merits of the assertions and allegations, the writ petition is dismissed as not entertained with liberty as granted. We started.
My lord, one submission should I made, my lord. The lathi charge, the place on which JP Golambar, where the lathi charge has been done, my lord, the Chief Justice house is nearby that. Even that the Patna High Court would have taken the same order.
No, we don't do. You may move a petition, that's it. Next case.
With great respect, my lord, the petitioner is the victim of, my lord, land grabbing, my lord, by the land mafia of crores of rupees, my lord, by, my lord, forging the, my lord, title documents and, my lord, transferring those, my lord, crores of rupees, my lord. Rather, my lord, session court, my lord, page 33.
The accused is your first cousin.
My lord, accused is the, my lord, Manoj Chaudhary is the, my lord, cousin, and the property of the petitioner is the, my lord, purchased property, not, my lord, the joint.
It's a property which was purchased when? Which year?
My lord, property was purchased by the, my lord, petitioner and petitioner's father, my lord. Those sale deeds have, my lord, already been given to the, my lord, police. In session court is, my lord. Yes, my lord.
The property was purchased primarily by the your father, but there are also documents which they are relying upon to show that it was a common or a joint property, and they've acted on that. There's a civil suit already pending. We intercede the parties.
My lord, civil suit regarding cancellation of the forged sale deeds later on filed by the, my lord, petitioners, my lord.
That will be examined. We are not going to go into all that. We are not inclined to.
Lord, my only submission is in similar, my lord, petition Honorable Justice Surkant, my lord, in appeal number 1793 of 2023, my lord, I have, my lord, raised this, my lord, ground 5.9, my lord, at page 16, my lord. 16, my lord, page, my lord.
1 minute, please. These are matters relating to facts. These are primarily decided on facts. These are not a question of law.
And my lord, in that case, I also primarily, my lord, this is organized crime, my lord. By the my lord, land grabber here is my lord Neeraj, my lord Chaudhary.
Trying to interfere with the impugned judgment and his specially petition is just the same order in 49.
And my lord, even no findings given by the my lord High Court.
Okay,
And page 33 onwards, the
next case.
my lord cogent findings are there, my lord, by the session court, my lord. Those have not been, my lord, considered. If my lord kindly see the page 33.
That's all, Mr. That's all, Mr. Chaturvedi. Next
My
case.
lord. My
Lord, state was virtually logged in.
Who's there for the
State
state?
virtually logged in. He was virtually logged.
He has cooperated with the investigation, your lordships. I have taken instructions.
And what about his role?
Your lordships, he was
website-
using the app, your lordships.
The website he is mentioning.
Your lordships, he was using the app, your lordships.
He is also a victim in a way.
Yes, your lordships.
Our complaint case is
Okay, leave granted.
Lordship, may confirm
Leave granted.
earlier order.
I ordered it. 4th of October 2024, while issuing notice in the present appeal, we had noticed submission made by the appellant of having availed services of Zinca Logistics Solutions Private Limited, a Bangalore-based company providing trucks, online truck services through their website. Stop. Next page. It is submitted on behalf of the state that the appellant Shashi Bhushan Singh has appeared and cooperated in investigation. Stop. Next page. Keeping to the facts and circumstances of the present case, we accept the present appeal with the direction that in the event of appellant Shashi Bhushan Singh being arrested in connection with FIA number 177 of 2023, is at police station Kalyanpur, Bihar, under sections 379, 406, 407 and 420 of the Indian Penal Code. He shall be released on bail by the investigating arresting officer trial court on terms and conditions to be fixed by the trial court. FIR number is page 31. Take the FIR number from page 31. Stop. The impugned judgment is set aside and the appeal is allowed under aforesaid terms. The petitioner, the applicant will comply with the conditions mentioned in section 438 within brackets 2 of the Code of Criminal Procedure 1973. The applicant will also provide one mobile phone number on which he can be contacted by the police officers while on bail. The appeal is allowed in the aforesaid terms. We clarify grant of anticipatory bail to the petition to the applicant will not be construed as an expression of opinion on the merits of the case.
Grateful, my lord. Grateful.
I appear on behalf of the petitioner in the first matter.
Because I am in 3.1.
Lord, the first
Yes, please. Yes, please.
The first question that arises and really is not considered by the courts below at all. Lord, I am third party. Property belongs to me. Property, my lord, it is not even an averment.
Look, you're not a third party in a way because you're the legal representative of the deceased partner.
No, he was not partner. I'm sorry. That's what I'm saying. My husband. My husband.
They have not challenged the injunction of.
Let me point out two things against.
Sometimes what happens is, when there is a partnership deed, there are extensions which come about.
That's not even their case.
Therefore, you have not challenged, even in fact, you never challenged the first order also. Status quo order.
The order of Justice Arif Doctor confirming the arbitration order, ordering status quo in a 37-22. Not challenged.
Look, I see that, but that should not come in the way of me for the reason. Lord, before I start, Lord, let me point out two things against me, and I will start with that and deal with that. 2014, from the account of the partnership firm, 50 lakhs is transferred to my husband. 2014. There is no. I have stated.
And your husband was a partner.
No, husband was not a partner. That's where we Lord.
Agreement 60-40. There was an agreement between him and the partnership.
There is
50 lakhs was transferred.
That's what I'm saying. May I just point out the chronology? 2014, the amount is transferred to the husband. Nothing happened. After his demise in 2016, Lord, I'm the wife. I'm Lord, two sons. We are staying in US. Lord, we wanted to develop the property since we are staying in. One of the partners, Lord, is actually occupying Lord, part of the premises, and that's the reason we entered into an development agreement, registered development agreement, by executing a power of attorney in favor of that partner. That development agreement is before your lordships. Proceeding on the basis that Lord 50 lakhs is received, Lord, it is not even.
Let me put it this way: in civil suits also, A and B enter into an agreement. The consequences of that agreement or an injunction order can be felt by C, D, and E. But that doesn't mean that the contractual clause will become. And if we interpret it very narrowly, then the arbitration process will become unworkable.
No, Lord, may I just point out, Lord, the relations between the partners? Lord, I'm sorry.
This is his first question.
Yes.
On the injunction by the arbitrator under 17 confirmed in 37-2.
Yes.
Till today, there is no challenge by you.
Lord, I will make amends for that.
Learned judge finds brazen violation of the order while ordering the section 9 and receiver.
Lord, I see that. As far as the partner is concerned, he has to answer that. Lord, therefore, I'm saying, Lord, insofar as I am
bound because the partner is injuncted.
No, Lord, therefore, let him be injuncted. I have no difficulty about that.
No, you'll be hit by the status quo.
No, Lord, therefore, keep aside status quo. Today, I am questioning, Lord, the appointment of the receiver. Lord, a party who is not party to the partition deed, who is not, Lord, there is no, even according to.
Can't be here. You've been heard now.
Lord, even please see, Lord, the averments in.
If we narrowly interpret this, no civil court or for that matter, any arbitrator will be able to work.
Lord, may I just
ensure enforcement of the injunction orders.
Lord, may I just point out the legal issues
the
that arise?
Money is certainly flowed from the partnership.
I say that. Therefore, at the most, Lord, your lordships can direct me to bring that money back and deposit Lord, either.
The rights are created in the property. You are forgetting that.
No,
Once you accept that the money has to be paid back, then the rights which are created in the property itself, in terms of the partnership deed, will come into play.
No, Lord, there is no agreement executed between the partnership firm and my husband or me.
May not be.
Lord, it will be two.
Partnership firm works in a different principle.
May I just.
Probity and the understanding between the partners is governed by the law of partnership.
Lord, may I just point out the legal problem which arises as a result of this? Lord, I can't participate in the arbitration proceedings. I am not partner. Everything will be decided in my absence with respect to property exclusively belonging to me. There is no transaction entered into between the partnership. It is not even the case.
Correct that even your affidavit.
Yes.
Support is sworn by Mr. Savlas.
I see that. Therefore,
the lawyers are the same.
No, there is a reason for that. There is a reason for that. It's my specific case that yes, development after the demise of the husband in 2016. After the demise of the husband,
you'll be fighting a proxy battle. That's all.
Lord, the result will be, Lord, in my absence, I can't participate in the arbitration proceedings. In my absence, my property rights will be examined and decided.
The balance sheet of the partnership firm.
I'm sorry.
The balance sheet of the partnership firm shows Virar property as part of the partnership's assets.
Sorry, Miller.
The balance sheet of the partnership firm includes your property at Virar as a partnership asset. How do you get over that?
Your lordships may go on the basis of that and ask questions to my learned friend insofar as I am concerned.
I have a different point to make. I mean 3.1.
I just before my learned friend starts, Lord, I need a solution for my problem, Lord, which Lord, I can't.
You are a problem. You don't require a solution.
Lord, I can't participate in the arbitration proceedings.
You have accepted the status quo order passed by the arbitrator, confirmed by the single judge.
Keep aside interim arrangement.
And then what applies there should apply here because this brazen violation is found.
Therefore, Lord, keep aside the interim arrangement. Section 9 and Section 17 order, keep them aside. Lord, ultimately, when the arbitral award is to be passed.
Look, this always happens. This always happens. I don't know whether Order 1 Rule 10 principle will apply there or the subsequent procedure principle will apply there. But that will always happen. And if there is, if the partnership deals using the word assignees, etc., you may try and take benefit, become a party there.
Lord, I can't.
Please, I've given you the way out. I don't have to give it to you.
Because may I just point out, I am in item 3.1. I am 67% partner in the firm. There are two properties, Santa Cruz property, which is admittedly of the firm. I am not developing it. Other properties at Vira. The issue is it the property of the firm that arbitrator will decide? In the meantime, what in Section 9 High Court did was, it directed me to...
The injunction, you violated the injunction, therefore the court or the arbitrator had to take that strict step.
No, it's the appointment of court receivable will not inure to anyone's advantage. And I'm saying to my own disadvantage, allow me to complete construction. I'm not getting third party right.
No, wait.
The only business of the firm is to complete construction.
No, you can't do that.
I'm giving accounts. We have an IOD till December 2025.
We can't in a matter of coming up to this.
Today, there is a further situation which has happened.
This will help matter sort out.
Let me just
the injunction order will help better.
Let me just point out one thing. In the meantime, when we file the SLP, the arbitrator is now resigned. So mandate of the arbitration is over. There is no arbitration pending now.
Arbitrator will be
there is no arbitration pending today.
There will be fresh arbitration.
All I am saying is permit me to construct at my own risk.
No, sorry.
I am saying at my own risk, permit me to construct.
Not at all.
The order of status quo when it was passed, which my lord I violated. In fact, when the order was passed, I was already in construction.
Maybe.
So I have not violated any order to that effect.
Sorry, please. That's not that. We are not inclined to interfere with MPO judgment and hence specially petitioner.
Lord, may I request one thing? Insofar as I am concerned, Lord, this is interim order. Your lordship may, Lord, at least, Lord, clarify that this will not come in the way of my adopting.
That's obviously, what can you do? This order is binding on you as far as.
So therefore, interim order, it's okay. Lord, your lordship may at least clarify that, Lord, I need to have some independent remedy.
We have given you that option and go to the partnership deed. If it talks about assignees and regular representatives, you may have.
Your lordship may clarify that my independent.
We are not here to clarify. Next case.
As an agent of the receiver, permit me to continue.
To apply chloro in the reverse. I am pleading. I am not in it, but I am a party to the arbitration.
You want? We can do one thing.
Sorry.
We can do one thing if the other side agrees. You want to become party to the arbitration? We can't object to that.
In fact, they have filed an appeal.
1 minute, please. Do you want to become a party to the arbitration?
Would my pass it over? I will take instructions and will not make.
Okay, fine.
In the meantime, receiver I am not disputing. Let the receiver be there. Let me be an agent of the receiver.
No, please.
As an agent, let me.
No, please. On that part, we are just passing it over. Let us know.
In fact, the entire appeal memo is signed by Mr. Partner. He has.
Let him come directly in front. Why fight a proxy battle?
Wait, please. My apologies, but I was not present on the first round. That's on the first hearing, my lords were not partly and substantially not with me.
But tell us one thing. Now, really speaking, the issue will be based upon Forosol, now which has been explained by DLF. I don't know whether you've gone through those judgments.
No, not issue.
Para 20 of DLF, squarely covered.
Now it will be covered by that. Normally you are right, 6% interest, that too with quarterly risk, is unheard of as far as foreign arbitration is concerned. It's unthinkable because the rate of interest abroad is 2% 3% maximum.
And this is not,
It will become a huge amount because 6% with quarterly raise will mean something like 8%. This is unthinkable.
it is,
So now tell us, how much is the interest as per labor rate plus 0.5%?
6% simple.
What is the total amount?
Percent simple interest. That's the labor rate.
What is the quantum?
What is the quantum?
Quantum,
May I explain, my lord, in terms of
quantum would be, as per the award we have deposited.
Not as per the award, as per your stand.
That we'll have to count. I have the figures, but we'll have to find out the difference.
Okay, that much amount you pay them.
we have disputed.
We have
Undisputed
deposited, they
amount.
can withdraw.
No, you please pay them.
We'll withdraw and pay them. We have deposited.
And how much is the difference now between that and 6%?
That I'll have to get it.
Those numbers will have to, yeah.
Such simple interest we have already.
Mehta, in the first objection which you filed, when you filed for enforcement,
yes,
you must have raised. I was looking for that section.
I have not. I wanted to answer that. I was very eagerly expecting that question. What happened was, we raised two contentions. A, this is not a foreign award. And B, even if it is a foreign award, it's not enforceable in India.
No, the second contention was there cannot be two-tier arbitration.
Yes, two-tier arbitration. And second, even if it is, it cannot be enforced in India.
The matter went back on merits. The argument was only that inability to present the case throughout.
No,
I'm sorry.
Third argument. That was third argument.
Please, my lord, have a look at my lord.
No, Mr. Mehta, the difficulty in that is this. Constructive res judicata comes into picture. You could have raised this point earlier, you did not raise that point.
I raised preliminary issue.
Now, when constructive res judicata, when it comes to arbitration, must be given enforced strictly, otherwise arbitration will get prolonged.
No,
because you can then raise piecemeal objections.
No.
Now, that's why we said, please tell us what is the amount due and payable under the.
That, my lord, I'll place it. But give me
how much is it? If it's a crore of rupees, we are not bothered.
My lord, give me
more than a crore of rupees, we can still consider.
My lord, give me 2 minutes.
Give me 2 minutes for my satisfaction. They have suffered enough. For so many years, they have been here litigating with you. They must have spent more than a crore in litigation itself.
Yes. Lord, what has happened is, Lord, if I have 7 heads of award.
What is the amount difference? Tell us this now. Tell them, we'll pass it over. Tell us the difference. If it's less than crore, we're giving it a close.
More than crore.
It's more than crore.
Yes, sir. You are the figure.
My lord, the total outstanding amount,
it's about
including principal and interest at compounded rates, is 11 crores only, my lord.
And what is the amount as per the other one?
My lord, that I will calculate, my lord. It might be about 9 crores.
About 5 crores. My instructions are about 5 crores.
My lord, we'll just calculate and
just tell us the difference.
Your lordship may pass it over, my lord. We'll find out.
Pass it over.
Can it be tomorrow?
Okay, come tomorrow.
Very well.
Tomorrow. But otherwise, my lord, I'll just, my lord, give me 2 minutes. I stand by that. My lord, if I have 7 grounds, my lord, 7 claims, I have lost. And if I object one by one, constructive res judicata may perhaps act.
No, you may be wrong.
Allow me, my lord, to complete.
No, we'll enforce that doctrine even if it is not acceptable, because it will mean piecemeal challenge, because unlike section 34, where it is to be challenged within the specified time limit, as far as foreign awards is concerned, there is no time limit.
There is none.
So that will mean you can do it at 1 stage, 2nd stage, 3rd stage, 4th stage, which may.
Lord, can I answer that in law? Lord, forgetting the constructive res judicata?
It's a rolled up in enforcement with an objection.
Yes.
Vedanta, it's a rolled up procedure.
Yes.
Where it is partly execution, part recognition with the gateways.
Yes. Correct, yes.
In 48.
49 and 48.
48. So then, once you have a bite at the apple, now, as the Chief Justice says, will it not be constructive res judicata if certain grounds raised, not argued, not raised?
Please, would you also see for my satisfaction 48? That may bind me. I on demurrer.
Look, and let me put it, prima facie, we feel constructive res judicata should be made applicable to 40.
I bow down. I bow down. I have something else to show.
It will be in your interest also.
No, I'll settle. Lord, I have something else to show. Lord, the constructive res judicata would apply to me, the party opposing it. Please have a look at section 48. There are two ways. Section 48, my lord, if you Lord, section 48, conditions for enforcement of the award. Lord, where enforcement of a foreign award may be refused at the request of a party against whom it is invoked, that is me in this case, if that party furnishes to the court proof that, Lord, then A, B, C, D, E, F. Correct, my lords? Then 2. Now, this is what would govern my right, my liabilities, etc. Now, 2. Enforcement of an arbitral award may also be refused if the court finds. B. The enforcement of the award would be contrary to public policy of India.
No, look, I'll let you.
So that would not be governed by constructive res judicata.
No. My understanding is this. New York Convention has the effect of recognition of award all over the world, wherever who is a signatory.
That is 49 of our act.
Execution is possible at in any court where the properties of the judgment debtor or the one party which has suffered the award are located. Now, it's for them to ask for stay of execution because execution is direct. You don't have to ask for a degree of a court. You straight simply go for execution when you have a foreign award. When you raise objections, if you raise objections, those are dismissed. And in this case, if you read Justice Nariman's order, it says now the awards will be enforced.
Yes. Lord, even I must, my lord, in all fairness, tell your lordships, the enforcing court, kindly have, my lord, has recognized it.
Mr. Mehta, we need not go into all this. Just tell us the difference. How much is the difference? If the difference is manageable, we'll put it to the other side and finish it off. Why go into the legal?
Another aspect, my lord. Kindly, my lord, have a look at, my lord, the...
They must have why. What is the date of the award?
My lord, 2001, my lord.
2000.
My lord, I want to point out in their objection in 2003 to the enforcement, they raised the issue of interest, my lord. There, it was taken in the affidavit, my lord. The affidavit is not filed by them, my lord. I have copies here, my lord. Your lordship may have a look. They took it in the affidavit but did not argue it right up.
Anyway, let us know how much is the difference. We'll find some idea.
But tomorrow, I'll be able to. Oblige to your lordship.
What brings you back?
No, not.
Why did you come back? We said
didn't come
to
back.
be listed along with that matter. Why didn't
come
you
back?
listed?
The registry showed that the connected matters are listed today. I can't bring my learned friend, the AOR. She moved.
No, I was told somebody went to the registry and said, please get it listed.
No, my lord, please ask the registry. It was.
No, I wanted to ask the registry why they've listed it today.
My lord, I just take 1 minute of your lordship's time. There are two grievances that we have. One, because of the observations made in paragraph 103. And
we have understood that, Mr. Shantan. You had also mentioned that on that day. In spite of that, we said to be listed along with that appeal. We did not give a specific date. Now, please wait for that appeal to be listed.
Can I just say one thing? That these observations, I was not a party. My learned friend doesn't have any objection to those observations in 103 being expunged. I was not a party there. They said you haven't done due diligence.
Fine. Look, please.
Yes.
We understand that. We'll examine that. But how is it affecting you?
It is. I'll tell you. That's the urgency. In NCLT, NCLAT, recovery proceedings under the RDB, they cite 103. I have those copies here. And there's
confined to this case. It's not meant for that. It's not meant for other proceedings. It's obviously in a case. Mere fact that you are negligent in one case doesn't mean you are negligent in all cases.
Please see, Lord. Can I just show you copies of this? What they are saying in NCLAT? Please see the copies. They are saying because of 103, I somehow.
But you can argue that. What are you arguing here?
Lord, with these observations of the High Court, which statutory authority is going to look at it?
No. 1 minute, Mr. Sarkar. You can always point out to the court or the tribunal that these observations confined to a case need not mean Non-character evidence.
Please understand.
Non-character evidence, as far as I understand,
I was not
Evidence Act is not a rule in India.
I have some 31 documents.
Only if evidence of good characteristic. Non-character evidence is not the rule in
Please appreciate. Either you examine it on the day when the connected matter.
We'll take examine.
But it can't be up to me.
You can raise that. We understand that.
My lord, the sting is in the tail. Let me explain why. Please see page 66. They are not asking for that paragraph 103. It's a very clever application. Please see page 66. 1 minute. Stay of the operation of number 103. He says that's in my absence. Second part is direction be passed to the nodal officer appointed pursuant to the order passed in the other SLP to get an NOC from them.
Correct.
Which means that they're exercising their rights over the property. While they are doing it only on the 103 and saying I'm objecting to some observation behind my back, the relief they're asking for your lordships is to accept their right over the property and that I must get a no objection. That's what they've asked before your lordship's court at page 66.
Can I complete, Mr. Ariyama?
Please see B and page 66.
We are not
I am the petitioner here. I don't get a chance.
No, you have your full chance for the next day. We are not impressed. We are not impressed by that.
Sorry?
We are not impressed by that argument. Does not matter to us.
Yes.
It does not matter.
21st, I'm told that the connected matter.
We'll take it up. To be listed in terms of the order dated.
That's 2nd January.
2nd January 2024. 2025.
Lordships.
21st.
To be listed